everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So the first thing I want to talk to you about is the H-1B rule. A little bit more, going to dive a little bit more into that rule, but only on about two things. So the first thing I want to dive into on that rule is regards to site visits. I suspect that we will see more site visits. The rule really expanded the authority of the agency to perform site visits. So keep in mind that the agency can and most likely will be increasing their site visits to the work sites listed on the application, as well as neutral locations. Keep in mind if the worksite location is a home address. So if you are working from a home address, that home address is listed on the application, then indeed they can and most likely will show up at a home address to perform a site visit. If you have a third-party worksite location, so if you are placing your employee at a third-party worksite let's say you're a staffing agency, you're placing someone at company A, USCIS will send people to company A to that worksite and look for that employee and poke around and ask questions and make sure that the work that you were supposed to be doing is actually being done. So keep in mind that if USCIS is unable to verify what was stated in the application, they can request further evidence. They can deny the application. They can also request to revoke an already approved application. So please keep those things in mind. If you have any questions about work sites, if you are if someone appears at your door, just understand that if you do not allow them to verify the facts, that that will either slow down the processing of your application or will potentially unwind the application with a notice of intent to revoke. So just keep that in mind. Second thing I want to talk to you all about this morning, which was also noted in the H-1B rule that recently came out. That rule again will be effective January 17th, so in a few days. Amendments to already approved applications. So if your employees and the employer has had any substantial changes since the initial application was approved, you are going to want to reach out to your immigration attorney and ask them some questions. Let them know about the changes and see if those changes merit an amendment. So changes that you want to look out for. Has an employee started working from home on a regular basis, again, since the approval of the application, meaning that work from home maybe wasn't included in the application. A home work site wasn't included in the application. Has an employee moved back to the home office or moved back to an office? So maybe an individual was at a satellite office, maybe they were working from home when the application was initially approved, but now a lot of companies are recalling their employees back to a central office, a central location. Was that central location listed as part of the initial application? If it was not, you need to look and determine whether or not an amendment to that initial application is required. If somebody was working from home and they changed their home, if they moved, and from a company perspective, maybe you don't care if they're in New York or Colorado or Oregon, but the Immigration Service does. So if they have changed their home location, you want to check in on your employees and get that information from them and double check that if that, what was put on the initial application when it was approved. Has the office location changed? So maybe y'all built out a new office, or maybe you took over another building in a different city or on a different side of the city. You want to make sure that no amendment is required. And if an amendment is required, that we get it done. And has your employee switched their internal job classification? If there has been a significant enough change in their job classification since the approval of the H-1B, then we need to look and see whether or not an amendment is in fact needed for that current H-1B. So sometimes things that we may not think about in terms of an employee changing their home location. So are they renting a new apartment? Have they gone from an apartment to a home? Are they living in a different address than was originally stated in the application that allowed for work from home? Those things kind of sneak up on us. But with the site visit, if there's a site visit to an old address and you weren't aware that your employee had moved, that may be a bit of a sticky issue for the approval and work authorization. So we want to try to avoid that. The next thing I want to talk to you about is cap gap. So cap gap is this concept that when students graduate, usually in May, although some certainly do graduate in December, but usually kind of talking about folks that have graduated in May, they then get their EAD, that is their work authorization document that is still in connection with their student status. Beginning of the fiscal year is October 1. Sometimes those EADs expire in June or July, kind of depending on when they were approved initially. And that left people sort of out in the cold in terms of having work authorization. So years and years ago at this point, the Immigration Service said that we would give you grace, and we understand that that is happening. So we're going to automatically extend your work authorization until September 30th, which is the end of the fiscal year. Because October 1, your application should be processed, and then you should either be able to start work October 1 in your H-1B status, or at that point you know that your application was denied, or at that point you know that you were not selected for the lottery. So all those things were happening. But what we've also seen in the past several years is a longer adjudication time for cap subject H-1B cases, such that the processing was not completed by September 30th, leaving those international students without work authorization from October 1st until the application was actually adjudicated. Well, this new rule essentially cures that and says we will extend cap gap until the date that you have requested, until we adjudicate the application, or until April 1 of the next calendar year, right? Whichever is sooner. So we're not just going to let you stay in cap gap until April 1. If you have requested a date prior to April 1 of that fiscal year and the Immigration Service has approved it before then that is when your cap gap protection would end. So that is huge. So we'll be seeing that we'll be coming up with that and using that in this current upcoming cap season. So let's just keep that in mind as we're watching our processing times after we have filed the H-1B. So that's great. Next thing I want to talk to you guys about is there is a new form. So we know that the H-1B rule is effective in a couple of days on January 17th. As part of that new rule is a new form, because why not have a new form? So we've got this new I-129. So if you are working with the old or the current I-129, it must be received before January 17th. So the last day that they want to see that the current form, we're going to call it the old form, the current form, is January 16th. As of January 17th, they will not accept the current/old form. They will only accept the new form. So if you're using the new form, it's got to be on or after January 17th. So just keep that in mind. You want to make sure that you're looking at the addition dates of the forms and making sure that we're filing the right form. If the right form is not filed, the Immigration Service will reject the entire application and send the whole thing back. The other thing that I think we're going to see coming out of this new rule is an increase in I-9 audits. And I think that's going to increase with the site visits. So we know that we know that the Immigration Service has now said, yes, we want to know what's going on at these work sites. Cool, we get that. With the new incoming White House administration, we also know that the new incoming White House administration is also big on workforce enforcement. And so we saw an uptick in I-9 audits during that previous administration. I think we're going to see an uptick in I-9 audits for the upcoming administration as well. So if when I say the phrase I-9, you are not quite sure what an I-9 is, you absolutely don't know what an I-9 is, and you're not quite sure if you're doing your I-9s properly, then you should either be doing an internal audit or you should be getting someone in to help you with an I-9 audit. I-9 audits can seemingly come out of nowhere. And so you want to make sure that your I-9s are up to date and up to snuff and they are looking good. So if that is something that you need help with, my office can certainly help you with that. The next thing I want to talk to you about is another addition to the visa waiver program. So Romania is now a part of the visa waiver program. They will be added to the ESTA online application system. We're being told probably by like March 31st, they'll actually be in the system, March 31st of this year. You'll be able to check that you're a national or citizen of Romania in the application. Until that online system is updated, you can still use your B1, B2 visas and enter that, you'll be entered as a visa waiver participant as opposed to a non-visa waiver participant. And so being a part of ESTA allows individuals from Romania to enter the US now without needing a visa for up to 90 days. And so your ESTA authorization is generally good for 2 years. So that's great news for individuals who are from Romania and looking to come over to the United States. The next thing I want to talk to y'all about this morning is the EB1 Extraordinary Ability Green Cards. I've gotten a slew of questions about these recently, so I wanted to kind of talk about them with you for a little bit. So the Extraordinary Ability is an EB1, which means it is a first preference category for a green card. And so in order to qualify for the Extraordinary Ability green card, you need to show that you have extraordinary ability in either sciences, arts, education, business, or athletics, right? And it's sustained national or international acclaim. What does all that mean? Science, arts, education, business, and athletics, fairly broad. So a lot of people, a lot of different industries will fit into EB1, right? Into this extraordinary ability category. And in terms of sustained national or international acclaim, what I tell my clients is that essentially we need to show the Immigration Service that you're the best thing since sliced bread in your industry or in your niche within your industry. And so what does that mean? How do we do that? How do we show that you're the best? How do we show that you have this sustained acclaim in your industry? How do we show that you're the best thing since sliced bread? Well, the Immigration Service really tells us, right? Whereas with some categories, they're very loosey-goosey about the language and we can be really kind of flexible and whatnot. The Immigration Service for EB1, Extraordinary Ability, really kind of gives us very clear guidelines. And then, we can be sort of a little flexible and creative within those guidelines. So the first thing is you can show us that you have a one-time, like, massive achievement award. So think a Pulitzer, an Olympic medal, an Oscar, an Emmy, something like that, right? But these are awards that are given by your peers, by your industry. It is not me saying that you are great. It is not you saying that you are great. It is your industry coming together and saying this person is amazing, right? Such that we want to bestow upon them this medal, right? Such that we acknowledge their body of work, and here is your acknowledgement in this big, big way. So most of my clients, I'll admit this, they do not come to me with these awards. And I get that, right? But that doesn't mean if you don't have one of these awards, it doesn't mean that you are not qualified for EB1. Because the Immigration Services recognizes that a very small portion of the population are getting Pulitzers, Oscars, Emmys, and Olympic medals, okay? So what they have done is they've laid out basically 10 criteria, and we have to meet 3. And the 10 criteria speak to the types of documentation that they want to see. The Immigration Service is all about the documents, right? And so the thing that these documents all have in common is that they are from someone, not me, and someone, not you. They're from people within your industry. So either people are writing about you, they are quoting your work. What are people in your industry saying about you? And so I'm not going to break down all 10 of them for you this morning, but just know that there are 10 criteria, and we have to prove 3 of them. I, of course, always tell my clients, the more we can prove, the better. So if I think you meet 6 of those criteria, we're going to talk about all 6 of those criteria, right? Another great thing about the EB1 Extraordinary Ability Green Cards is that you can self-petition. So either your employer can sponsor you for this application, or you can sponsor yourself. And so that's always nice for some folks. And because you can self-petition, there is no test of the labor market that is required, i.e., there is no perm application. A perm is where you go out and test the labor market, and you put out recruitment. You actively look for people to fill this role. Because you are the best thing since sliced bread in your industry, sort of the thought process behind it is that really there isn't anybody else out there who can do what you are doing. So again, it's all about the documentation that we can provide in that application. So EB1 applications are typically very, very document intensive. They tend to be very thick applications in terms of just volume of paper. So I wanted to kind of talk about the EB1 Extraordinary Ability Green Cards because I have been getting a slew of questions about them recently. So I figured I would do it in this larger forum as well. So if you have any questions about EB1 Extraordinary Ability, your I-9 compliance, whether or not you think you may need an amendment to your H's or your other applications, or you're not quite sure what to do if there's a site visit at your work site, please feel free to reach out to our office. We're happy to have that conversation with you and help you through this. I am Carol Williams with Williams Immigration. This has been another Monday morning edition of Beyond the Soundbite. So I hope you'll have a wonderful rest of your Monday and a great rest of your week.